Hi, I'm Therese Aroyan from Family Property, and today I'm going to cover Family Property Tips number 1, initiating application and response. Today we are going to go through the mandatory initiating Federal Circuit and Family Court forms and the relevant rules. We are busily building the new court forms into Family Property, and I'll be giving you a demonstration of the new initiating application and response we are launching shortly. The Central Practice Direction sets out the new case management pathway for family law matters. The listing pathway you can see in front of you is for all family law proceedings except for matters that are urgent, are in a specialist list such as the Abbott or Magellan list, or have been varied by court order. We are going to be focusing on the initiating documents today, and in the context of the forms we will be talking about, the Central Practice Direction must be read in conjunction with other relevant practice directions, as it sets out the need to comply with orders, practice directions, rules, and the possible consequences of non-compliance. It requires that parties file as soon as possible so that the parties and the court can proactively identify the significant issues in dispute, gather evidence as early as possible, and be fully prepared for court events and hearings. This is a list of all the initiating documents. There is the initiating application or response, the genuine steps certificate, an affidavit only where interim orders are sought. In financial matters, the financial statement and financial questionnaire. In parenting matters, the parenting questionnaire, notice of risk, Section 60I certificate, or affidavit non-filing of FBR certificate. It's important to note that there may be other documents that might be required depending on the orders you're seeking, and you should look at the relevant practice directions for each type of proceedings. The other important thing to note is there may be some exemption on the basis of things like risk or urgency, and you should see Rule 4.012 of the Federal Circuit and Family Court of Australia Rules 2021 for further information. Rule 2.011 sets out the types of applications that can be filed. It has the initiating application that we're going to be going through today. It also has other application types such as the application for consent orders, application for contravention, and application for divorce. The other important thing to note is that there is an application in a proceedings, which now replaces the application in a case. And with respect to that document, there is a maximum of 2 applications in a proceeding that you can file without leave unless there are urgent circumstances. Rule 2.29 sets out that an application and other court documents filed with it must be filed as soon as possible after the date of filing. And Rule 2.31 states that unless otherwise directed, an application and other court documents filed must not be served less than 3 days before the day fixed for the hearing of an interlocutory application, or less than 7 days before the day fixed for the hearing of any other application. And this really goes back to those objectives in the Central Practice Direction, that parties can identify these significant issues as early as possible, gather the evidence, and be prepared for court events and hearings. Now, if we look at the form itself, it is very similar to the old court form with some very minor differences. It now says the Federal Circuit and Family Court of Australia. It also has a note that parties must complete and file a genuine step certificate with this application. Otherwise, it is very similar, other than some wording changes and the insertion of some fields such as the email address for the applicant and respondent. In relation to the response, that must be filed in the approved form in accordance with Rule 2.18 when seeking to consent to an order sought by an applicant, when asking the court to make another order, when asking the court to dismiss the application, or asking for orders in a matter other than as set out in the application. And that response must be filed and served within 28 days after service of the application to which it relates. If we look at the response, again, it is very similar to the previous response. It has the new court in the left-hand corner, and again has the note in relation to the genuine steps certificate. There has been removal of some of the types of orders sought, but otherwise remains very, very similar, with the insertion of things like the new email address field. The Genuine Steps Certificate is a new document. Applicants and respondents must file this, certifying that they have complied with the pre-action procedures and taken genuine steps to resolve the dispute, or if they have not taken pre-action procedures, the basis of any claim for the exemption from compliance. If we look at the document itself, it has a lot of information about the pre-action procedures that are required, but if we move into the court form, it has a section for the pre-action procedures with a checkbox, and then also the grounds on which an exemption can be sought. An affidavit should only be filed where an interim order is sought. And when we're looking at interim orders, a party must not file an interim order or interlocutory order unless there is an application for final orders that is current in the proceedings, or the application includes an application for final orders. The affidavit document has some information above. It sets out that this form is now used in both family law and general federal law proceedings, and you'll see that there is the type of proceedings box in which you need to select which proceedings you are filing this affidavit, but otherwise is very similar to the previous document. In financial matters, a financial statement and financial questionnaire must be filed. The financial statement, other than the changes to set out Rule 6.6 and the duty of disclosure, the form itself is very similar, and this is a form that has already been built into FamilyProperty and populates all the information from our balance sheet into this form, which makes this form, the creation of this form, very easy for clients and practitioners. It's very important to note that in financial matters, there is now a rule, Rule 2.10, which sets out that parties must file a copy of any family violence order that affects a party. The financial questionnaire is a new form that parties must provide information, including a chronology of relevant dates. And if we open this, it sets out also contributions made pre, during, and post relationship, both for yourself and the other party, and also seeks information about future needs. And this will be available shortly within FamilyProperty. In parenting matters, there is a new form called the Parenting Questionnaire, and this must be filed by the applicants and respondents when they file their application and response. And the Parenting Questionnaire has around 58 questions, and it includes things like current and future parenting arrangements, the information in relation to the children's health, in relation to safety issues, in relation to schooling, housing, childcare, and financial support, amongst other things. The notice of risk has changed. It is really important to note that the notice of risk must be filed both at the commencement of proceedings and if any new facts or circumstances are raised during the court proceedings. And if we open that form up and just have a quick look at it, we have sections in relation to child abuse, and family violence, in which you set out the types of abuse or family violence that has been experienced by both yourself and the children, anything that has been done including any reporting, any court orders or family violence orders that have been made in relation to those allegations, and also whether a party has been convicted or charged in relation to those allegations. There are also parts in relation to mental health issues, abduction or threats of harm, and other concerns. The last section of the document seeks that you detail the alleged abuse and what action, if any, was taken and by who. The Part J sets out which orders are required to protect the safety and well-being. So what orders you would like the court to make to protect the safety of the child, and what orders you want the court to make to protect your safety. The requirements in relation to the Section 60I certificate remain the same. There are the exemptions to the Section 60I certificate, but it is important to note that if you are seeking interim orders when you are filing your application, that you do not need to fill out the affidavit non-filing FDR certificate, but you must address the circumstances in which you seek the exemption within the affidavit that you file that supports your interim orders. And again, it's very important that you're aware that under Rule 2.10, in parenting matters, parties must file a copy of any family violence order affecting the child or a member of the child's family. If we now go on to the demonstration, we'll go into family property. Now, this is the balance sheet after the parties have filled in the questionnaire, or the lawyer has filled in the questionnaire. This will populate into the working balance sheet so that you can model some proposals about the proposed property split. You'll see that the assets have been included with a description of the item, who owns it, and the value that your client says is the value of the item. This slider allows you to set out whether or not the matter should be retained by your client, transferred to the other party, or sold. If you click on these items, you're able to edit this information as required. It's really beneficial that you fill in as much of this information as possible, because this will then generate into your relevant court forms. In this circumstance, there is already a proposal entered for the purposes of this demonstration, and it provides for the parties to both retain a property, to divide some money in their bank accounts, that the parties will retain their cars and retain some household contents, and this provides for a 47 to 52 split in Sophia's favour. The reason why it's really important to fill this in is that whatever proposal that you set out in the balance sheet will generate into the initiating application or response, depending on who you are in the court proceedings. If we move on to the parenting tab, this sets out all of the children that have been entered into the questionnaire. The questionnaire allows you not only to enter the children of the relationship or the children to which the dispute relates, but also any other children that live in the home. So we've entered a new feature called the in dispute feature, which you can identify whether who the children are in relation to the dispute, so that it's very clear which children are being discussed for the purposes of the dispute resolution or court proceedings. Now, if we click into one of the children, you can edit the information or set up some parenting arrangements. And so in this, for the purposes of the demonstration, we've put in some orders to allow for the parties to spend alternate weeks and other special occasions, including some changeover. And this, again, if you fill out prior to generating your court forms, will generate some orders into the application or response if that is what you would like to see happen. So if we move to the documents now, you can either access the smart forms through this section here, or through this More tab here, which is where you can also access the smart form. So if we do that now, I will launch the initiating application. And what you'll see is a preamble that sets out some important information about the initiating application. And there are links there for your convenience, the pre-action procedure document, and other rules that link to the particular section in the rule that is relevant. If we move down, the drop-down has been updated to include the Federal Circuit and Family Court of Australia. There are less order types to now select in the new court form. If you select the include generated orders, that will include the proposals that I've just shown you. And as we move through, you'll see that the information in the questionnaire has populated into the smart form. There are certain forms that are unique to the smart form, and that this will allow you to enter that information, and it will auto save so that you don't lose any of that information. So if we keep going down, you'll see that there's second applicant, there's the details of the respondent, the details of the relationship of the party, and the children. Within the children's details, you can identify whether or not this the parenting arrangements are in dispute about this child. If no, then they will not populate into these smart forms. Now what I will do is generate this initiating application. And what you will see is that this is the new form populated with all of the information that is relevant to the smart form from FamilyProperty, including the final orders or proposals that we saw in our parenting tab and in our balance sheet. And if we keep going, you'll see that the document has been populated with the information that was entered into the smart form. Now we will go to the response so that we can quickly show you what that looks like. Now the program will know whether you're the applicant or the respondent by you launching the correct form. So again, the response to the initiating application has a preamble, which has those really important links to the pre-action procedures, including the pre-action procedure brochure for financial cases and pre-action procedure for parenting cases. Again, provides for a link to the rules so that you can easily go to that information. It sets out when you might need to file an affidavit with this form, as well as the fact that it must be filed on all other parties. So if we again move through this response, you'll see that the Federal Circuit and Family Court is there to be selected, and all of the information has again been populated from the questionnaire and balance sheet into this document where it's relevant. And again, I've selected that I want the proposals that I've entered into FamilyProperty to populate into the document. And so as we move through this smart form, you will see that the information has been populated into the smart form. And again, there are some unique fields in this smart form and questions that you'll need to answer and fill in. And again, you'll see at the bottom of the form that there is a link to the Marriage, Families and Separation brochure for your convenience. So let's generate that now. And we'll move it or open it and move it across into the screen so that you can see that. And you'll see here that there's there's the applicant, and then there's the first and second respondents. And again, the document has been populated with the proposals that have been entered into FamilyProperty. as well as the other information that you've entered into the smart form, and that was populated into the smart form by the client or by the lawyer filling in the questionnaire. So if you'd like a demonstration of family property, or if you're interested to learn more, please get in contact with us or click on the link in this presentation so that we can organise a demonstration or refresher session for you if you already own family property. Thank you very much.